So, good morning. Welcome to all of you, and welcome, Pauline. We got only your first name up there, Pauline Tesler. I wanted to just say a few words. It's really difficult to say only a few words about Pauline Tesler, especially as it relates to the collaborative practice movement. There's more than enough words that I could say about Pauline, my friend, but just in connection with the collaborative practice movement. There are a few people better known throughout the world in connection with collaborative practice. Pauline literally wrote the book on collaborative practice and has since updated that book for professionals, and has written a book for the layperson considering collaborative practice as well. And that itself is a wonderful book for professionals as well to read. I took my very first training from Pauline Tesler in January of 2000. She and Stu Webb offered a training down in Dallas, and I flew down there to take that. And as it turns out, I've taken my most recent training from Pauline Tesler and Woody Mostyn in St. Louis, Missouri, a mastery class. I just want to thank you again, Pauline, so much for joining us, and welcome you. And let's have a talk. Okay?
Good morning. I'm looking forward to a conversation.
Okay, good.
So let's see where we go with this.
Okay. So as I pointed out, you've been involved with collaborative practice basically right from the start. A co-founder of the International Academy of Collaborative Professionals, its first president, and again, literally wrote the book, the ABA book, on collaborative practice. Maybe share a little bit about what brought you to collaborative practice way back when.
Oh yeah, well that's a story of desperation, really, and it's not unusual for lawyers, and especially for family lawyers round about mid-career. What I discovered, and what a lot of us discover who are doing collaborative practice, is that it doesn't matter how good a lawyer you are. It doesn't matter how terrific a job you do in the courtroom, how smart you are, how skillful, even how empathic. Once a family gets caught up in the court system, nothing good happens. I often quote a very well-known appellate judge here in California, Don King, who was a terrific family law judge, and what he summarized it all as after his retirement is that divorce court is where they shoot the survivors. So if you care about doing good work and feeling good about your professional life, after a while you notice that whether you won or whether you lost, whether you did well, whether you did not so well, the clients' faces look the same, miserable. So I didn't think I could continue doing that after a certain point. And I began really a lengthy search for other ways to look at what I was then calling dispute resolution. We call it conflict resolution now. I was looking for models from other cultures. How conflict is inevitable. Everybody experiences it in their lives. How do other cultures deal with the kind of structured cultural assistance to people in conflict? Was there a better way? And I looked at psychological models. I looked at Jungian archetypal psychology. I was looking everywhere. This was in the mid-90s. No, it was earlier than that. It was in the late 80s. Not a happy camper. And it was in that mix of frustration, search, and absolute inability to imagine continuing doing family law in the courts that I heard about Stu Webb's inspiration His inspiration came on January 1 of 1990. He tells that story about just declaring unilateral disarmament. And it wasn't long before I heard about it. There was a little article in one of his professional newsletters in California in 92 or 93, and I saw it. And the metaphor that I've used is that it's like dropping that last bit of sugar or salt into a supersaturated solution. And one of the vivid memories I have from studying chemistry in high school was all of a sudden, poof, you've got crystals forming, and those crystals were forming all of a sudden in my mental construct of what it meant to be a family lawyer, what it meant to be a lawyer. And what Stu's idea gave to me was the notion that you could reinvent it. And I had come to this from being a public interest lawyer. I was used to assuming that the system was not doing it right and that I could do it better. I'm a child of the 60s, and I'm not modest about attacks on institutional structures. I always assumed that if I just thought about it, I could do a better job than what was happening. You know about that, right?
Yeah.
So that was it for me. As soon as what Stu's idea gave me was permission to just see what I could put together if I wanted to do it in a way that made sense to me. And using Stu's construct of what if the lawyers just couldn't go to court, signed binding agreements that whatever happened, these lawyers were not going to be adversaries meeting the parties in court. And then from that, I'm going on and on, but from that, discovered Peggy Thompson and the work that she and Nancy Ross were doing about interdisciplinary team services to provide the other kinds of support from the mental health and financial services industries professions. And that's the journey that's taken me here.
Within what you described, Pauline, I hear two components that always strike me as part and parcel of collaborative practice and why people are drawn to it. And on the one hand, it more engages the practitioner than does litigation. It's better for the professional, and the results are better for the clients. So there's two pieces of collaborative practice that I hear in what you're describing. Is that something? Do you share that perspective of that? Yeah.
I do, although actually it's interesting that you put it that way, because I think just recently, over the past couple of years, I've started understanding that really it's two things only, in the sense that, the drawing of the yin-yang with the black and the white sort of fishy things. Those look like two things, and they're really one thing. And similarly, although it looks like lawyers doing good stuff for lawyers and then lawyers doing good stuff for and with clients, I'm starting really to understand that what we're talking about are human systems, which is one thing. And that part of the difficulty that lawyers have had with making this rather profound shift to thinking about what we do with our clients differently is that the part that legal education and even experience on the job tends to leave out of the construct is we lawyers, until we stop doing this, we tend to think about ourselves as sort of the given, the constant, the unchanging thing. I'm me. I'm not different. You're a new client. You're a different thing in my professional scene here. So any variables going on here must be all about you, not about me, because I'm the same wherever I go. And that perspective is really, it's not really looked at. It's not visible. And it's one that stands in the way of professionals seeing that as soon as we walk in the room, any room, a new system happens because we've changed the system by entering it. And so when we're working with a family system, which is what a divorce is, it's a family system that's reconfiguring. It's coming apart from one household, and when there are kids involved, reconfiguring into two households. When we lawyers think about it as, well, that's about them and their problems, and me, the lawyer who does what I do, and I am who I am, I'm just going to bring that and help these people fix their stuff. That isn't how it works. The way it works is I walk in the door, you walk in the door, the professional team sits down at the table with a couple, and we've created a brand new system. And we hope.
Sure. As best I can.
So do you know where it left off though?
I just to let people know what happened was we had an internet crash, and so the recording stopped, and now we're picking it back up. Thanks, Pauline, for coming back in. You were talking about each time the attorney enters a room with the family, basically, a new system is created. My words, see if they fit, but it is a recognition that the professional is not a blank slate, but rather an active member, an active participant in the process. Is that consistent with what you're saying?
That's kind of how I'd put it. I wouldn't really say, even in more traditional ways of practice, that we professionals ever think of ourselves as blank slates. We're a little bit too egotistical for that. But it's more that we tend to think of ourselves as, I do what I do. I'm a lawyer. I've had my training. I got my skills. I'm at the peak of my game. So that's a given. And anything that goes wrong, any problems, any challenges, they're all about you, the client. They're not about me, because I'm the same wherever I go. So I must be the constant and you must be the variable.
Yeah.
And what I'm really seeing so vividly is that every single time two or more people sit down together, and in a collaborative case, we often have as many as 5 or 6 or 7 people around the table.
Yeah.
We're creating a complex human system. And one of the big variables is me. And first of all, I'm not the same every day or every minute. I change in dynamic relationship to everybody else at the table. And I'm not the same in relation to you, perhaps, as I am to somebody that I'm not such a good friend of, or that I haven't got such a good history with, or somebody that I don't know well at all. And how I respond to conflict and uneasiness during negotiations is going to change depending on what that particular system and moment is. So that perspective, it may sound obvious, and in a way it is obvious, but if you really, as a lawyer, start thinking about the implications of that, what it means is, in order to do this job well when we're working in a model that everybody's at the table, it was a lot easier when we lawyers used to bargain as agents. The clients were nowhere in sight, and you and I would cut a deal. We knew how to do it. We know what the solution should be. But when everybody's there, and the goal is a kind of a deeper understanding and acceptance of the resolution that gradually emerges from the conversation, if that's what we're trying to do, then the dynamics of that system at the table have a huge impact on whether and how smoothly and how effectively we're going to get to that point where the clients whose story and whose solution it is, the clients say, okay, yeah, I can embrace that as the best solution given all of the things that we now understand. But if I'm standing in the way of that, if I'm still behaving like somebody whose job it is to jockey for position, to get the biggest pile of every measurable goodie on my client's side of the table, that changes that system, and that system can't accomplish the same things. So it's about me, not in the bad sense of, gee, everything's about me, but in a good sense of seeing that I've got to self-regulate. I've got to be as exquisitely attuned to myself and my impact on that system as I am to anything else.
Yeah. Our own, that we do have an impact, and recognizing that we do, and thus having the self-awareness to recognize how we do have an impact.
Precisely.
Yeah.
Precisely. So that instead of behaving as if the only part of me that matters, or the only part of anybody that matters, is, that prefrontal cortex that does all of the high-level cognitive processing, behaving as if that's the only thing that we should pay attention to and everything else is kind of a digression.
Yeah.
Recognizing that the emotional context from which the conflicts emerge that we're working with,
Right.
that's the most real thing in the room.
Yeah.
The cognitive part is abstract and not messy, nice and neat, and we can classify and categorize and prune off the messiness. But the clients leave that room and live these lives like we all do that are much more complicated and not neat at all.
Right.
And emotion is the engine. And so my work now really is paying a whole lot more attention to what that means once we professionals notice that and take responsibility for it.
Perfect lead in. I'd like to ask you a little bit about the work you're doing now, just by way of segue. I mean, you've been doing trainings in collaborative practice for a long time, and are obviously highly sought after as a trainer. And I know that you're doing, because as the thought leader that you are kind of leading yourself into more of what you just described. So can you tell us a little bit about what you're embarking on these days?
Yeah, I'd love to. I'm still, of course, and always will be deeply devoted to doing work in the collaborative community, doing trainings, and I love doing advanced seminars and workshops with people who've been doing it a long time, because it's so exciting to keep on learning with people who are making discoveries, just the way I am from struggling with the work. But out of that, I think about 4 years ago, I began integrating into my collaborative trainings, the more advanced trainings, and now even some of the introductory ones, this perspective, the systems perspective, and this integrative perspective that says that body-mind awareness practices, positive psychology, the neuroscience of conflict resolution, the apology and forgiveness movement, powerful non-defensive community, that all of these vectors, which are out there as kind of separate disciplines that we all know exist, those of us who are working in the collaborative field for any length of time, and they all relate to the work that we do as collaborative lawyers. It suddenly struck me as I was integrating that material into my advanced trainings that everything, all of those different vectors, as Susan Dykhoff has called them, they're all part of this one thing. I keep coming back to this notion that we're talking about conflict resolution, human conflict resolution systems. We become part of it as soon as we start working with new clients and other professionals. And that all of these different approaches, which we lawyers, we go out and take continuing education courses here and there and workshops and conference workshops to develop skills in these different areas. But increasingly, it seems to me, we're seeing that these are all integral parts of the education and competencies of lawyers who want to work in this client-centered, interest-based way with clients, so that we're not brokering deals, we're helping clients discover solutions that emerge naturally out of the facts and the priorities and the values. So as I started integrating more of those vectors into collaborative trainings, I started thinking that really these are the competencies and understandings that any lawyer needs to have, not just collaborative lawyers. If we're going to work with conflicts that arise out of fundamental breaches in trust relationships between humans, obviously that applies in spades to divorce. That's the most intimate relationship that a human can have, is a marriage or an intimate partnership. And divorces arise out of some breach of that deep trust. That's what makes the connection that keeps an intimate relationship going. So I started thinking, well, what other kinds of legal disputes really arise out of this profound breach of trust in a human relationship? And if you start thinking of that as the relevant category, then you start seeing a very clear distinction between the kind of work that lawyers do when we're interested in ruptures in the trust-based human relationships as the engine for the dispute that gets defined as a legal dispute, versus the kinds of lawyering that lawyers do when they're interested in tax law or Microsoft versus Google. Those are not about personal ruptures of expectations of trust in a kind of a one-on-one way between individual humans. So Julie McFarlane, who's, as you know, is a law professor in Ontario, she wrote about this as the difference between fundamentally personal disputes and non-personal or business or commercial disputes. And the place where I'm taking it is that the quality of these human disputes that are amenable to this complementary law perspective that I'm talking about are problems that arise. The ground from which the legal dispute arises is this rupture of an expectation of trust, a legitimate expectation of trust and integrity between and among people. So this would apply, for example, to a small business or professional partnership that's breaking up. What happens usually that causes that is two people or two or more people get really mad at one another because somebody's done something or not done something that violates an expectation that it isn't an intellectual expectation. It's not just about the words on a contract. It's, I expected better from you. You violated something profound between us. And when I say profound, I'm not talking about like a marriage, but nonetheless, it's a rupture in a human relationship that fuels what the lawyers then abstract into the elements of a cause of action. And if all we do is deal with that abstract cause of action, the fuel, which is the ruptured human relationship, just keeps on keeping on. That's why in divorces particularly, you see that revolving door where you get the matter settled, quote unquote. What we settle is the legal causes of action. But here's that ruptured relationship that just keeps on finding other places where the conflict can live. And so you find motions for modification, motions to set aside the judgment, you find violations of terms of agreement. And we all know that there are divorces that can last a lifetime because of that, because they never really got resolved. So.
There's so much in that. Just a beginning point. What you are describing in terms of it, embracing the emotional elements of divorce were, for me, exactly what it was. Not the light, it was a bottle rocket that went off in my head when I took that training back in 2000, because I sat there and at that time there was no talk, there was hardly any talk about collaborative teams. It was we were just beginning to discover what a powerful thing that was. Right. That it's not just, quote, adding on a couple of other people or sending the clients out to be fixed by therapists. It's profoundly different. Yeah, right. But the bulk of what was being offered was to lawyers only. And what lit me up, because as you know, I'm a lawyer and a licensed mental health professional, was this notion, this dream that I had of expanding for the attorneys who do collaborative practice their command of the same kind of skills that mental health professionals use in working with clients. And it's gone a lot farther than I even dreamed at that point. But that's what I hear you describing, is attorneys who actually recognize and work to enhance the value of those skills in themselves and embrace the use of others who are even more skilled in doing it, and recognize that sometimes it's better, it's simply better to have someone else work with that element the dynamics in the room.
As with so much of this, once you name it, once you have the right way of looking at it, it seems obvious and you can't imagine that you didn't see it before. Which is to say, if you start with the clients, what are their problems? What is it that anybody, for example, going through a divorce who's got kids, what is definitely going to be part of the terrain? Well, we know that we lawyers can abstract from that mess of kind of operatic stuff. We can abstract elements like here are the elements that we need for a divorce in this state. Here is how property is divided. Here are the rules for custody and visitation. We can do that, but no client ever came into my office and said, I would like you to file a petition that alleges that blah, blah, blah. The client comes in with this story, and the story includes breakdown in communication, breakdown in trust, deep disputes about, about parenting, which often is a reason why marriages end after kids arrive. Deep dissatisfaction with the levels of intimacy in the relationship. Arguments about money. Sorry, I got still a sore throat here.
Sorry.
The mental health professionals often say that the real dirty secret that no couple talks about is not sex, but money. And so if you start looking at what's propelling the client's narrative, I didn't learn how to do financial planning and teach people how they can talk honestly about the underlying facts of their financial situation. I wasn't ever trained previously in how to facilitate clear, respectful, constructive communications. If we've got clients and who of them aren't upset, deeply upset at times to the degree that they can't think straight, and that's happening in the negotiating room, I've got better skills than I used to have about what to do in that situation, but still I'm never going to be as good at it as a mental health professional who works with high conflict divorce. If we have in the room at the table a financial person and allies who can help each client when those moments of intense emotion arise, can work with them in advance and coach them to get back to a place of constructive problem solving, or to express in a way that it can be heard what this problem is that's just blown up in the middle of the table, everybody does a better job. So it's not that I need to do all those people's jobs in order to be good at this, but that we have to all know enough about one another's professional terrain that we can do a kind of a seamless dance in the room where I can lift my eyebrow and look over to the coach for my client, and the coach picks up right away and carries the baton for a while in terms of facilitating what needs to happen next. And same with the financial person. Mm-hmm. So it's teamwork, which is far more complex than simply providing interdisciplinary services to the clients. It's learning to work as a team in the room as we help them.
Yes. Yeah, vastly different from from the lawyers frequently engage other professionals, but it's always I am in charge, and you are being hired to render an opinion that I need in this case, or if you don't have that opinion, then you will simply be filed away and nobody will know that I ever talked to you.
Exactly. I'm in charge. I get to fire anybody who's not following my game plan. Exactly.
Very different mindset.
And of course what happens, which was unexpected, is once you're working in that I started by talking about trust-based relationships and the breach of them with the clients and how we have to be a functional professional system working with a dysfunctional family system. Well, the team itself can get dysfunctional because we're all human beings. And that's really what I was trying to express about how, no, not me, you maybe, not me. But, we're right there in front of God and everybody, and there's no hiding. If I'm the one who has just changed the air in the room in a bad way into something negative and polarized, everyone else at that table knows it, except me. And if I'm in a model where I'm in charge and I get to fire all the other professionals, the thing that happens next is profoundly different from if I'm in a model where the protocol is we take a break and the professional team maybe has a quick conversation about what just happened there and what are we going to do now. And it may be that I'm the focus there and I'm going to have a powerful learning experience whether I wanted to or not.
Yeah.
And, I've been writing about that lately, that the teams have become the most powerful emergent learning system imaginable for learning how to do this work effectively.
Tailing off that last point you made, it seems to me that it's an opportunity to fuel the kind of self-awareness that you were talking about to begin with.
Exactly right.
And it requires a different type of strength of ego from the type that lawyers are used to thinking they're supposed to have. It requires a strength of ego that can hear critiques and assess them and find value and learning opportunity from the critiques, as opposed to, well, what do you mean there's something wrong with me? I did my job. I was right. Well,
Well, I think that's really how it looks and how it feels when somebody operating from a conventional paradigm, a conventional lawyering paradigm, looks at what I've just tried to express.
Yeah.
In fact, I don't think when it's working, when collaborative team practice is working, it doesn't feel that way. And here's what I mean by that. Another aspect of how everything is connected and all is one is that the learning of the individual lawyer about how to do this very sophisticated team conflict resolution, the individual lawyer's learning curve is inseparable from the learning that takes place on each team for each case, and is inseparable from the work that happens in a well-run, effective practice group. Because it's in the practice group that the trust relationships, and this comes back to these human trust-based relationships and the expectations of integrity that those relationships give rise to at a biological level. We're talking about like the wiring of a primate species that has to function effectively in small groups. And so we've got wiring in our endocrine system and in our brains, in our neural pathways that need small group trust-based affiliations for us to function properly. Mm-hmm. And paying attention to this is a big part of the teaching I'm doing now, making it more conscious and aware. The practice group is where we build those kinds of trust-based affiliations, not the kind of deep ones that happen in a marriage or a family, but the kind that happen at the professional level where, for example, I've got a colleague.
Sorry about that.
I've got a colleague here in the Bay Area who I've been working with for many years. It's your phone, not mine. Who, when we begin a new collaborative case together, sometimes, depending on the case, if it's people who are sophisticated enough to understand that this is money in the bank for him, what he's about to say, he'll say, I just want you to know that Pauline and I have worked together for many years. We have done the work of learning to trust one another. And the way I feel about Pauline is that if I were to die tomorrow, I'd want her to be in charge of my children's trust funds, inheritances. And to be able to make that kind of a statement, what that means is, whatever happens in this journey that we're all going to jump into on any given matter, Larry and I know that we are not going to be the problem, not because we don't make mistakes, because we do, but because the relationship that he and I have together professionally matters enough that we're going to fix it. We are not going to inflict dysfunctional, mistrustful, suspicious professional relationships on an already dysfunctional system that needs our functional system help to reconfigure. So Larry and I are making a statement that's true, which is if he or I does something that's out of sync with the commitments that we're making about constructive problem solving, I have the kind of relationship with him and he does with me that we're going to go out of the room or have a debrief and we are going to clear that up. And that's not going to foul the stream. We are going to be functional problem solvers because we trust one another and we expect it of one another.
Yeah.
Does that make sense? So
yeah.
When you do the work in the practice group and on the cases, on teams, of really getting to know one another and learning what one another's values are and what we can legitimately expect and not expect from one another, then when something happens, you had started by saying, how difficult it would be from an ego perspective. I know it sounds a little bit touchy-feely, but it isn't. It's hardwired neural stuff that happens. Yeah. It shifts, and it's not about I'm me and you are other. And when you say something critical of me, it's an assault from somebody who's not part of my small trusted group. But when we are affiliated in this way that's based on trust and experience and shared values that we've been explicit about with one another, then when you call me to account in a kindly way after a blunder may have happened that may have been mine, unbelievable as that might be to me, there's a sense in which, even though it's not fun, I can see that you're doing something constructive for me because I can't do good work unless I can learn to see that when it's happening. Mm-hmm. It does, in fact, get to that place with very experienced practice communities.
Yeah.
If we're not at that place, then we're in the terrain of cognitive biases where I can see exactly what's wrong with you and there ain't nothing wrong with me, thanks.
Not that I have any stamps in my passport from journeys in that land.
I imagine you do.
Yeah. I wanted to. I know all of what you've been talking about. You're also expanding it's your not only your awareness and learning in it, but your efforts to make it available to more people. That's kind of where.
Oh yeah.
Yeah. So, talk a little bit about those newest undertakings that where you're bringing what you've been learning over the last 20 years now.
This is very exciting for me, and I went off on such a digression about team practice, which I love to talk about, that I forgot to tell you this really important thing that's happening in my own career path, my own work path. You know that I've been doing training for many years now, approaching 20 years in the collaborative community, and I love doing it. And I've been balancing that with and a lot of writing and a lot of speaking and organization building with earning a living, which is in my work with clients. And as I've seen this much broader applicability of this notion of lawyers in conflict resolution systems and the integration of these many vectors of awareness of how we affect systems, I realized that this is the next contribution that I have to make, and that it's the synthesis of everything I've done so far. And I'm very, very determined that I want to be able to spend all of my time and energy taking those ideas that I've been prattling on about for 10 or 15 minutes now with you. I want to be taking those ideas and training any kind of lawyers who are willing to come and hear about it. Teaching law professors about this perspective so that it can be built into law school curriculums. Working with lawyers from any field, not just family law, who have hit that wall in mid-career of thinking, I came into this to be in a helping and healing profession, and oh my God, what's happened? I can't do this anymore. So I realized that to do that full time, which is the way I need to do it now, means that I have to make a shift from funding this work out of my own pocket, from the work that I do with clients. I need to move into the nonprofit realm and do this full time. And I've started an organization that's called the Integrative Law Institute at Commonweal. And that is a training and education vehicle for lawyers, for judges, for law students, and for the general public about this perspective on personal conflicts that's grounded in the really hard neurosciences, which are teaching us about our legacy as human primates, and that it's not optional that we work in these small trust-based affiliative groups. It's the only way we can, in fact, work. And that when we're not doing that, that's when we're in this mindless adversarial conflict that has become the mode of solving every problem in our culture. And it's not working. We all know it's not. So my intent is to take these insights, and one of the things I seem to be good at is to take complex material from a variety of disciplines and filter it through my own experience as a lawyer and as a builder of this team model. And I can translate it into concrete practical applications that have to do with the work we're encountering every day with our clients. So that's what I'm going to be doing. I'm going to be doing MCLE, that's mandatory continuing education courses for lawyers, initially in urban centers all around the country and online. And I'm going to be doing residential workshops for lawyers, and I hope for law faculty as well, young law faculty who may be getting excited about what the neurosciences and positive psychology and the apology forgiveness movement and all of these vectors might mean if what they want to do is teach law students how to come out of law school prepared to work with other human beings about the conflict that drives these legal problems. So that's my agenda. Commonweal, where my program is based, is a nonprofit organization with a long history here in Northern California. Their mission is environmental and social health and justice. And they have had programs running that do this same kind of work in the medical profession, reclaiming medicine as a healing profession. And one of the ways that I'm describing what I'm doing now is reclaiming law as a healing profession, not just for divorce lawyers. So I'm excited.
It sounds wonderful. God. A quick informational question. When you say residential workshops, you mean like on-site at Commonweal? Is that what you mean by residential?
I think initially it will be at Commonweal, which is an absolutely gorgeous location in Marin County, West Marin. I like to describe it as being on the Japan side of the San Andreas Fault. It's out on a cliff over the Pacific Ocean, and it's absolutely stunningly beautiful. And it's one of those places that seems to be a natural healing environment just to be there. So as a program of Commonweal, naturally I'm going to run some of the residential workshop programs there. And I think probably I'll begin, I'm not certain of this, but I'm thinking I'll probably begin with weekend workshops for lawyers, mid-career lawyers who really want to reclaim some integrity and values-based practice in their work. So those will be on site. Eventually, I hope to have much longer, perhaps week-long residential workshops for young law faculty who want to learn how to teach a curriculum that we'll be developing. And then I intend to go around the country to various locations to do shorter chunks of MCLE, continuing education for lawyers, in half-day and day-long chunks in any number of locations. Chicago, for example, would be a nice place to come and bring that.
Yep, not a bad place.
Not bad.
Does it fit to talk in terms of shifting particular just for the moment addressing only attorneys, to shift the mindset of the professional from I am the one who either has or will find your answer to I am one who is willing to support you in finding your answer?
That's a key element in this shift that happens as we learn how to do this work that actually does resolve the conflict, not just the legal dispute that's at the tip of the iceberg, but the conflict.
Yeah.
I mean, that's an ambitious hope, and naturally that's not going to happen in every matter. But the profound shift includes this getting rid of this notion that our job is outcome-based, that what you and I are supposed to do as lawyers is to jockey and negotiate and do anything that's not prohibited to get the biggest pile of stuff for our clients, even if the relational costs are immense. Traditional lawyers, I did this, I'm sure you must have done it at one point in your life, we don't even ask clients if what they want is that last $100 or $1,000 or $5,000. And to push hard enough to get it can sometimes involve such intense costs within a family system. It's irreparable damage. There's never the possibility of reestablishing a parenting relationship. And, if you shift it around and you say to a client, well, how much is it worth it to you to sell the possibility of dancing together at your daughter's wedding? Would you sell it for $5,000? Mm-hmm. Would you sell it for 10? That's really what we lawyers do when we are attached to brokering outcomes. And when we shift to this notion that the clients are going to generate the solution, this is easier said than done for lawyers because we're so wedded to that outcome measure of our success as professionals. I know I did a great job if I got you $100,000 more than you thought you were going to get. Mm-hmm. And I don't measure the human costs of it. So shifting to the clients developing their own solutions means shifting everything. Everything changes when we get rid of that notion of what our job is. Because that means that we can't have a predetermined notion based upon what we predict a judge is going to do or not do as to the range of measurable outcome. Instead, those solutions have to arise out of understood facts about the client's situations, shared situation, financial facts often, but not just financial facts. Because if it doesn't arise out of a shared understanding of the facts from which the solutions emerge, then the clients are not going to own them and embrace them in the way that resolves it so it's a deep resolution of a conflict, not a superficial legal solution. Well, how do you do that? It means that the lawyers we've got these knee-jerk habits. We may facilitate full disclosure of all of the information the clients need to then generate options and decide which ones are going to work best. And then we get to that final point, and many of us, even some very good collaborative lawyers, and I'm not rid of it yet. It lurks there, and we have to watch for it. There's this stab of anxiety that we lawyers feel. We think, I can't let my client do that. I know if I took this case to trial, I could get $100,000, $200,000, $500,000 more for my client. I can't let my client do that. And you still hear it. You still feel it.
Yeah.
And to shift into a profound client-centered conflict resolution model is to understand that perspective is a law-generated perspective that does not arise out of the client's experience. We still have an obligation as lawyers to make sure our clients understand that something different may or may not happen at the courthouse. Of course, it's far less predictable than some of us think it is, but we nonetheless have a non-waivable obligation as lawyers to make sure before our clients sign an agreement that they're content with, that they're kind of inoculated against their friend next door saying tomorrow, you did what? Well, I know somebody who got 5 times more than that. So if only for that reason, we have to make sure that clients understand what might happen if they didn't do it this way. But the artistry in doing this kind of work is to do it in a manner and at a time that supports client-centered decision-making rather than undermining it right at the end when their lawyer has a spasm of adversarial knee-jerk habit and says, I can't let you do that, which happens. Yeah. It happens.
Yeah, yeah. Some of that, it strikes me, involves an expansion of a understanding of the simple word costs. It's very common for attorneys to say you could get $10,000 more, but it might cost you $8,000 to get that much, and to get that $10,000, so you've only got $2,000 extra. And what you're saying is that common approach, while it recognizes some of the needs of the client, the economic needs, can be expanded and serves everybody better if it is expanded to include what are the costs to your future relationship with your soon-to-be ex or your children or even, your extended family.
The children's ability to be with their cousins and their grandparents and aunts and uncles, and one's own sense of integrity. I often talk with clients about you're going to look back upon your own behavior and how you conduct yourself here. And one way you might want to think about what we're doing now is, what are my own personal values? What do I hold as deep beliefs about how I want to conduct myself in life? Yeah. And how do I want to look back on how I did conduct myself? Because this is a bookend. There are those pictures of the wedding. That which we're facilitating as divorce lawyers is the other bookend on a major life passage, a major chunk of life history. And the bookend that we're creating is how I know what my hopes and dreams were for the marriage. Now, how does how I conducted myself at the end of this marriage, how does that fit with the kind of human being that I am, that I want to be? Yeah. And it's not that we're substituting our judgment for our clients or telling them how they have to be or how they should be. But we have enormous power as the professionals that they're coming to at a time of great vulnerability. And everything that we pay attention to and don't pay attention to is an instruction about how you're supposed to behave if you want to handle yourself in a socially appropriate way during this time of great stress. So if my client comes in with this complicated narrative in the first interview, and the only thing that I write down is when she tells me how much the electricity bill is every month, and apart from that, I'm sort of gazing off into space and every now and then trying to pull her back to what I think is important, which is what are your monthly bills and what's on the tax return. If that's my style, I've informed my client that the only thing that matters in a divorce is quickly getting orders about how the bills are going to be paid and then getting as much out of the cash flow and property as I possibly can. If I work in that first conversation in a different way with the narrative, and I hear my client talk about the children, and I fail to explore what my client's hopes and dreams and values are for the children going forward after this divorce, and what kinds of relationship with the ex-spouse, soon-to-be ex, would be required to realize that for the children, I am not meeting my ethical responsibilities to hear what my client's goals are and work to achieve them, or at least, at minimum, not to thwart them. And I think many divorce lawyers work directly contrary to interests that they don't even bother to find out about. And therefore, they're telling the clients they don't matter by their indifference to them.
Yeah. So again, so much in there. I think what I want to ask you at this point is about where you are in terms of the Integrative Law Institute. How far along in that process? How much longer do we have to wait for this?
Not much longer. The Institute is now officially a part of Commonweal. The Board of Directors unanimously invited me in to be their newest program. Now all I've got to do is raise the money. And so I am actively looking for philanthropists and foundations, small family foundations, and donors who are going to help me make this real. I have a business model. I've learned enough over the years to know that you got to do that. And it's a good business model because if I can get funding so that I can spend full time on this for, I estimate, maximum 3 or 4 years of subsidy, this will be a self-supporting program because it's going to generate the fees of the lawyers who I think will become very interested in it when they know it's available. So when will the first programs happen? Well, I am talking with people in New Hampshire about probably giving a day-long event. We're talking probably June. I think it's going to be sponsored by the State Bar, and it's going to be talking about the neuroscience of conflict resolution in collaborative and other kinds of disputes. Yeah. So that, I think, is going to be the first official event of the Integrative Law Institute. And I'm working now to schedule what I think is going to be probably a 3-day weekend workshop event. I hope at Commonweal, but if not, somewhere in the Bay Area at a rural retreat location, for lawyers who are interested in learning all of these integrative vectors and how they can connect with a values-driven practice of law in whatever field they happen to be in. So I think I'll be announcing some dates for that. I hope I'll make the announcement within a month or two and that the dates will be probably September, October, somewhere in there. And then, if all goes well, I'll be moving around to offer day-long programs in various city locations for MCLE by early 2013. That's my ideal timeline.
Great. Is there available to the public information about the goals, the structure, the nature of the Integrative Law Institute?
It depends on whether the Commonweal webmaster has got it up yet this week or whether it goes up next week or the week after. But there is going to be a lovely description at the Commonweal website, and that's going to link to the Integrative Law Institute's own website, which is under development. So you're talking with me at a moment when everything is fermenting and taking shape, and I would guess that by the end of March, there will be a program description up on Commonweal's website, and there will be at least the beginnings of ILI. That's its acronym, Integrative Law Institute, ILI. ILI's website will be up as well. Oh, and I forgot, there's also going to be, at Commonweal, they have a wonderful program called the New School. The founding director of Commonweal, Michael Lerner, is the son of Max Lerner, who was one of the founders of both Brandeis University and the New School for Social Research in New York. And in honor of him, his son Michael has started the New School at Commonweal, which does interviews and conversations like this with all sorts of scientists and people in the arts, and also their own program directors, and they become podcasts and videos that are available online at Commonweal's website. So I'm going to be doing a conversation with Michael Lerner later this month or early April, and that'll go up as a podcast on Commonweal's website.
Okay. So you and I will stay in touch so that I can keep sharing the progress with our readers, right?
I'd love to talk with you anytime. Anytime I can talk with people about this, it's just very exciting to me.
I get that, and it's an infectious excitement. I want to be mindful and respectful of your time. We've been at this nearly an hour. There's so much more that I know every time you and I talk, we get off on these things, and they fascinate me. But I think this may be a good time for us to close for now. And
probably so. Although as I'm closing, I'm realizing there is one other thing that, if you'll allow me, I do want to mention.
By all means,
people are interested.
Yeah.
The Strauss Institute for Dispute Resolution at Pepperdine Law School has decided that they're going to do another round of advanced 3 or 4 day, 18 hours of credit for an advanced collaborative intensive workshop program. That's going to be in Maryland, at the University of Maryland, in the spring of 2013. So we're talking a year out. But I'm very excited that they really do want to do this, and I'm going to be doing it with David Fink again. So people might want to think ahead to that.
The connection blurbed a little bit. With whom are you doing it again? I just wanted to get that person's name.
My co-trainer is going to be David. My co-trainer will be David Fink, who I did this with last time, and the Strauss Institute is going to be running it with the University of Maryland as a co-sponsor.
Great.
So I'm excited about that too. Anyway,
That's
thanks
awesome.
so much, Carl Michael. I really enjoyed talking with you.
Same here, as always. So I'm going to just end the recording. Bye, you all, and
Bye.